see that we have 56 participants. I believe that people will continue joining as we are continuing. Share the link, tell your friends to tell a friend to join this educative platform. Before we start today, I want us to have a prayer from Dennis Onyango, who is the Secretary General of ADR Club. So Dennis Wafula, please bless our session. Dennis Onyango.
Adeline, a minute, I guess he's unable to unmute. So maybe a minute.
Okay.
Okay, let's pray. Father, we thank you for this afternoon. Thank you, Lord, for the preparations you've given unto us, even towards this webinar, to be able to share and have a discussion about justice for your people, community justice, people-centered justice. To may be able to have great coordination, even with our moderators, the parts they discuss, Jehovah Lord, and even our listeners, King of Glory, and even for the areas they have concern, Jehovah Lord. We pray that you may lead us and guide us. We pray this, trust, and believe in Jesus' name. Amen.
Amen. Okay, thank you so much, Ms. Aluda. Dennis will do our closing prayer for us. So welcome everyone once again to the webinar on multi-justice systems and communities via radio and online programs. This webinar to you by University in partnership with the Center for Multi-Justice Systems, the Radio Jambo, as well as Amani Community Africa. So before us, you see we have a lovely panel. Forgotten to introduce myself. My name is Adeline Chelagat. I am the moderator. I'm the Law School Association president, and today I shall be moderating with Mr. Gordon Ogola, who's the head of the Center for Multi-Justice Systems here at Kabarak. Now, without further ado, I want to move on to, first of all, we shall have Ms. Jemima Aluda explain to us really what AJS is, together with her work around this place. And then I shall basically state the objective of this webinar. So over to you, Ms. Aluda.
Okay, thank you so much, Adelaide, and thank you our viewers and listeners today. Thank you for joining this important webinar. As Adelaide has mentioned, my name is Jemima Aluda. I'm an advocate of the High Court of Kenya. I'm here and my capacity as the head of Secretariat for the National Steering Committee on the Implementation of Alternative Justice System. This is a committee that comprises of various stakeholders, chaired by Professor Justice Joel Ngugi, who is the judge of the Court of Appeal. It has representatives from the judiciary, Office of the Director of Public Prosecution, civil society, the academia, probations, the National Police Service, Law Society of Kenya. So it actually comprises of so many stakeholders with the key mandate of promoting or be able to implement the policy on alternative justice systems. So we all ask ourselves, so what is alternative justice systems? So these are organic mechanisms that exist in our community, in our societies, in terms of handling disputes, but not necessarily through the formal systems that we've always had. So we can talk about the traditional mechanisms. We can talk about the culture that people have come up with in terms of dispute resolution in their various spaces. For instance, students have a culture of dealing with their disputes. The matatu industry have a system of dealing with their disputes. The border industries, the markets committee. When you go to the market and somebody has a dispute with a customer or a dispute between the sellers, they have a way in which they deal with disputes. In our various places where we live, we have ways in which we've developed dealing with disputes and not necessarily following the formal court system. So we call them organic because they just you just realize that these are systems when you're born from birth, you find the system are existing, or when you go to a space where people are like where you are in a new environment, you find there's a system of dealing with, even in the estates. If maybe at a workplace, you just find there's a system that is existing, and organically you find yourself abiding by these social norms and the culture that people have developed to deal with. The constitution itself, under Article 159, says alternative. So people say, why is it alternative? So that's the reason why we call it alternative, but mainly they are the main ways in which we deal with in terms of dealing with disputes. So they include the use of religious leaders, use of our leaders in the community, the issues of mediation, reconciliation, our elders in the society, at the family level, and all this. So they are very comprehensive.
Thank you so much. From that point, actually what Karaoke Migua also said, instead of calling them alternative, yeah, we call them appropriate, because that is what we majorly use. So thank you for that, Ms. Aluda. Now, Ms. Aluda has given us a very good introduction of what the AJS system is. And I shall now just briefly give what the Center for Multi-Justice System is here at Kabarak and the objectives of this webinar, and then move now to introduce our panel as we flow to our next session. Now, here, the Center for Multi-Justice System is a dynamic department, yeah, within the Kabarak School of Law that seeks to transcend the classroom arena in terms of advancing alternative justice systems. So the Center for Multi-Justice Systems, it draws inspiration actually, as Ms. Jemima had said, from Article 159, from the AJS policy that has actually been launched. And we seek to revolutionize the traditional approaches to dispute resolution. Now, we want to do this through innovative research, education, community initiatives that seeks to bring the community together in resolving disputes. And basically, the objective of this webinar today is, first of all, it is a precursor to the AJS conference that will be happening at Kabarak University from the 4th to the 7th of June, where we shall be discussing, about the AJS, engaging, expanding, and retooling the AJS system. We shall be having a lot of guests, with our chief guest being Mother Kome. So karibuni kila mtu. Our audience, please take note. Tupatane huko. And because of this webinar today, we saw it fit to, have a pre-discussion on how we can use online media platforms and radio platforms in advancing this multi-justice systems. And that is why we invited the panel that we have today. I shall first start by introducing Ms. Joy Getao. So Ms. Joy Getao, if we could see you. Welcome. So Ms. Joy is a visionary leader. She is a practitioner and trainer in mediation. Ms. Joy Getao, on a professional level, is first of all, she holds a law degree from Catholic University. She holds a postgraduate diploma from Kenya School of Law. Ms. Joy is a certified professional mediator and mediation tutor and mentor with Amani Communities Africa. And she has been trained in family mediation, youth, religion, among many other things, actually. Currently, she serves as the executive director of Amani Communities Africa. She is in mediation. She's a mediation practitioner, a tutor, a mentor. She is a board member. She's a legal director. I mean, this is just the tip of the iceberg. Should you decide to say her credential will be here the whole week, but just this shows you how Joy is qualified to speak on, matters regarding multi-justice systems. And the other panelists who we had invited, I believe they do not need any, basically a household name. So this is Ghost and Gidi. We first start with Mr. Jacob Mule. I see he's here with us. So Mr. Mule is a co-host of the Radio Jambo, the Patanisho Guru, as we popularly know him for. Aside from being in the entertainment space, Mr. Mule is also a professional soccer trainer. He has been coaching teams throughout Africa and has coached our national teams. So we have, a person who's proficient both in the sports department and in the radio department. That is very key in our discussion today. We also have Mr. Joseph Oyo, popularly known as Gidi, who is also another Patanisho guru. Besides him being a musician, he also holds a master's in data science and business analytics from Comms School of Business. So this is also a person who is not only a qualified entertainer, but an academician, yeah? And you would all agree with me, yeah, fans of Patanisho who are here, that, when you look at them, how they dissolve these disputes, these are people with keen listening skills, yeah, these are people with exceptional abilities to reconcile people. Oyo and Mr. Mule, I don't know if I can call you Ghost and Gidi for the purpose of this session, but it's okay. So we shall now move on to the questions that we had prepared for the panelists. And maybe we can just with you, Miss Joy, could you tell us, seeing that you're very qualified in the mediation space, of your experience being, do you think it's better than going to, what have you experienced? What have you seen as the benefits?
Thank you very much. And I'm really so thank you very much for that starting question. Actually in law. So there's a way in which, I mean, based on just your client's story, and the other part just for the purposes of making sure you strengthen your client's case. So my training is in law. So I came across mediation a few years back, and it was a paradigm shift to what I knew, was a paradigm shift to how I look, my perspectives on even what conflict is about, what is about conflict. So basically came to open up my mind and really what I know as a lawyer, right? So there are so many benefits of mediation, and maybe just to describe, mediation is basically one of the many practices my senior when it comes to that multi-door approach that is offered by our constitution, because on some of the issues that are coming up, their needs, their interests, basically getting them to a point where that they're all agreeable to. Yeah. So mediation for me was a world where it introduced a friendly process. So first of all, it's a friendly process. That's one thing I can say, which is actually one of the benefits. It is a process where you have parties actually decide for themselves what is actually a good solution for them. So it's a solution by them for them. Okay. Mediation is actually a process that does not take long compared to a traditional dispute resolution systems, mainly litigation, which may take up to so many years. I believe if we start going into how long cases can take, we would be here the whole day, because some of them are like 1980 cases. I mean, it's really terrible. But mediation offers an opportunity to resolve the conflicts in a fast way. Mediation is affordable, yeah, and that's one thing that people need to know. It's affordable when you think about it from a time perspective. It is affordable when you think about it even in terms of how much you would pay a mediator to actually sit down and help you resolve a dispute. And you also have mediators who are actually working on just giving their services. So again, it's accessible from a financial point of view. Mediation is also flexible. It has no technicalities. We don't have bureaucratic systems in the mediation. When you approach a mediator, you just follow through a process. We don't have things for pleadings, get another date. When the date comes, so and so is not available. I mean, mediation is basically something that is fast, it is affordable, it is friendly, it is people-centered. And really that, I believe, is what speaks to the vision that our current judiciary has under this social transformation through access to justice. When you talk about a justice system that is transformative, mediation is at the forefront of promoting these very values, you know. So that's what I can say about mediation and how it compares to the ordinary, you know, court systems and everything. Though there is a place for that, I must say that. But one thing I'll also say, in mediation, you also give the parties an opportunity to transform their relationship. Because over and above discussing the substantive issues, the core issues that bring the parties to mediation, they get an opportunity to transform how they will envision their lives together moving forward. If it's a business relationship, you'll have conversations such as, this is an opportunity to improve our policies. This is our opportunity for us to grow ourselves in a certain way. So I think mediation offers a win-win situation, you know, an opportunity for needs and interests which may not even come out in a court of law would actually be addressed and met. And I believe for me that is a huge selling point for mediation. Yes. I hope I've answered your first question. Yeah.
And yes, you've answered it fantastic. Thank you so much, Joy. I do not think I could phrase it any other way. To note, you said that it transforms the relationship. So in court where, you know, mnakasirikiana, umenishinda, I have to pay you money for winning against me. But you see now in mediation, both of them get to walk away, yeah, with a win-win situation. And now I pose my next question to Ghost, who is here with us. So could you explain to us, yeah, in the nature in which you resolve your disputes? Do people walk away with a win-win situation, Kilasa? So explain to us, you know, what is patanisho for audiences who might not have interacted with it, and what type of disputes you deal with, and what are the success rates when you go on with, you know, the program. So let's hear from you.
Okay, good afternoon, everybody. First of all, I'm happy that I'm in this webinar. And for those who don't know patanisho, I think maybe, or you've not heard of patanisho, it's your first time. I would like to welcome you. I think a lot of people know patanisho. I mean, I think patanisho in an English word is mediation in short. And it's a program that we've learned for the last 16 years. And it involves about two people who have had some conflict of sorts. Mostly, it's about most of the conflict that we have, which is so funny, is about relationships. Most of the time, I mean, I could say 80% of patanisho is about relationship, married couples, people who are in a relationship, a man and a woman. We have seen even young couples. Sometimes it involves different people in terms of even bosses at places of work. whereby maybe somebody feels that they are not in good terms with their bosses, they also come for patanisho. So what happens in patanisho actually, it's people send SMSs. There are so many SMSs that we receive every day. And we have a producer who does pick at least 3 or 4 patanisho. Then what happens, because patanisho starts mostly at 8:30 and it runs for 30 minutes. So what happens, we call the aggrieved party, the person who wants patanisho, probably maybe, let's say, for example, it's the wife who wants to be reconciled with the husband. Then he gives a short history about what is happening, when did they maybe fall out, and then they say what happened, but we don't really go into details until we call the person who is aggrieved first. Then when we call them, they tell us a brief history of what is happening. For example, what we do, we ask about the age of the people that are being reconciled or mediated upon. And then after that, when we call, they tell us a small history about maybe we've been married for 10 years. And then we fell out maybe the last 5 years. Then we ask questions like, have you been in contact? They might say yes, or of late is that he has blocked me. I can't get through him or her. And then we ask, there are pertinent questions that we ask mostly in the African context or Kenyan context. Have you paid dowry? Maybe that is the reason that your wife went back home and said, no, I've not paid. Most of the men say, we were planning. I was planning. In fact, I told her that this August is when I'm going to see the parents. So we have this kind of thing. Then when we call, he or she explains the story or what has been happening. Then we call the other party. Then, of course, we ask them that, you know, so and such a person. They say, yes. Okay, what happened? She's saying that maybe she wants or he wants a reconciliation. Is it possible? And then after they give their side of the story, then we connect the two to talk. It's normally live, so we don't record it. It's what you hear in patanisho is live. There are no stories that have been made. No, it's a live patanisho, and that is why, for those who have ever listened to patanisho, you'll find that at times we call the other party. Unasikia somebody says niko kwa motorbike, ningojeeni, I have to park. Somebody says I'm driving. Sometimes they say they're in a matatu. So, and patanisho is strictly stays for 30 minutes. Although there are some very emotional patanishos that go beyond 9 o'clock, because we have 30 minutes to do the patanisho. Then 9 o'clock, we have the 9 o'clock news. Then we have a reaction of the listeners coming after that for half an hour. So mostly what we have found out is that in most of the patanishos that we do, should it be in relationship, sometimes somebody has had a problem with the bosses, we normally find success rate, I can term it as 80% has been successful. We have had marriages that have come back because of patanisho, relationship that have been reconciled. Sometimes we even have a lot of disputes, which like we've had people trying to fight for land. You find that maybe somebody was denied a piece of land by the father. He gave the other siblings, he was left out. And maybe because he was rude, he was indisciplined, and the father has decided that he should not see him there. And we try to talk. Sometimes the father said, no, you cannot come and solve this through the radio. I want my son to come back home, and then we have a meeting with the elders and all this. So there are all kind of patanishos. But one that I would like really to mention about that has stayed in my mind for a long time, was very emotional. I think we did it maybe 10 years ago. There was one lady who called and said that she wants to reconcile with the stepson because what happened, she had her own kids and they were age mates with the stepson. And what happened is that the stepson was very clever. So when he did his exam, he passed. Then the lady's kids did not do very well. So what happened? He organized for the stepson to be attacked by some guys. Actually, what they said that they even like sodomized him. It was a very emotional thing. And when we called the son, he said he'll never, ever, ever be reconciled with the stepmother because of what he did. And it was very emotional. And we stayed. Then after, I think maybe, I can't remember the time, the boy then called. His name was called Brian. And we read an SMS. He said that he's ready to reconcile with the stepmother. And when we called him, I said that he has forgiven the stepmother of what he did. I mean, it was very, very emotional to see that kind of forgiveness. And the story goes, the guy went to Mombasa, he got a very good job, and he came back and he built that stepmother a house of around 12 rooms, and he forgave her, and they had a party, and the rest of his history. So in a brief, that is what Patanisho is all about.
Wow, 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 wow. I wish there was a reaction so that people could clap. Others, has been a very fantastic rundown of what Patanisho entails. Wow, that's very, very emotional ones. And I'm very surprised to actually hear that you guys take land matter. Most of the time we've listened through, it's just been relationship matters. But, it's something fascinating to see that land matters are also being considered. Workplace matters are also things that are being, reconciled with. So I think you guys are doing better than the justice system. So, big up to you, Ghost.
Thank you.
Karibu sana. So in light of that, when you've stated that you only, I think the only difference between Patanisho now and maybe mediation process is the point of confidentiality, because everybody now can, listen to the matter. But others, I think it technically is mediation in the theory sense. Two parties have a conflict. We have a mediator come along and guide them to reach an amicable solution. So indeed, when you umesema patanisho can also be called mediation, I think it can.
Yes, and just to finish, it's a voluntary process, because we don't force anybody to come to Patanisho. They volunteer, they want to, and we have had cases whereby you call the other party, one party wants to be reconciled. There's the time we called a person that the wife wanted to be reconciled with, and he was very rude. He said, "What kind of nonsense is this? I don't want to be reconciled." And we had to respect that kind of thing. So it's normally, sometimes it goes south.
Okay.
Yes, Adeline, just maybe in the context of the clarification you are making, I would want to post one question to Ghost on this question of confidentiality.
Yes.
Have you had a situation where there's a conflict that is you are handling, and there's a likelihood of it being settled, but one of the parties tell you, I'm not very comfortable with it being on air? Would we be able to do it off air?
Well, we never do anything off air. What we do, we respect the party that says, "I'm sorry, I'm not able to do this on air. Let the person who wants to be reconciled with me call me privately." Then we say we respect that. Then they'll talk to you after. But we don't do it off air, because Patanisho is live. We do it there and there. We don't have that authority to do it off air.
Is there a situation where you've been confronted with a matter which borders on criminal offenses?
Yes. I remember there is a case that a jilted lover, somebody whose husband was cheating with a lady from Mombasa, and they organized, the lady from Mombasa, he organized with somebody else. She came into Nairobi, and they organized. The lady, actually, according to the story, is like she was killed in a hotel in Nairobi. And the DCI actually called our radio. They called me, and I went and testified. The DCI, we gave out the report. So sometimes it happens that way. It's a criminal thing, and That is how popular patanisho is, because even the police listen to stories. The people, sometimes they come and they confess on radio. They don't know that that could land them into trouble. So the DCI, we gave them all the whatever they wanted, and then they pursued that case further.
Thank you.
Thank you so much, Gordon. Thank you so much, Ghost, for clarifying that. Criminal matters are very sensitive issues. So to see that your platform can mediate on such high-level matters, it's to show that how effective people don't want to go to court anymore. Such programs can easily be used to settle matters. Now I move on to Miss Jemima. So could you please tell us, from what Ghost is telling us, is that as a matter of fact, radio is being used and radio is effective. Do you think that other online platforms can be used to disseminate legal information? For example, like such as mediation. Do you think that there's a possibility that soon we might be using Twitter, people of X now, that people can actually just text? You have a mediator in the chat box, they text, they resolve a dispute. Do you think that online media has a chance in the alternative justice system?
Okay, thank you very much for that question. And thanks for this great discussion. How can we use other platforms to be able to handle disputes in our communities? So first of all, I'll take us back to the Constitution. Article 48 tells us to, or commands people, or commands the government to ensure that people have access to justice.
Mm-hmm.
So it's talking about access to justice and not access to courts, not access to buildings, but talks about access to justice. And if you are tying it up now to Article 159, which is now your main arena in terms of your scope, talks that we should be able to have access to justice without undue technicalities. And so post-colonial period, Kenyans have been, mindsets have been towards to deal with the justice in terms of approaching the court system, in terms of structures, technicalities, filing papers, and affidavits. And you can see that this has really hindered access to justice for so many people. What the Chief Justice vision is, which is we are tying it to our topic for today, is having multiple doors approach, to have as many doors as possible to access justice, and not necessarily to use these structures that we've established in terms of the court, in terms of going to physical courts, and thanks to COVID that has enabled us to think outside the box. So as you think outside the box, what we're asking ourselves, are there other platforms that people can use to access justice, like just Twitter, Zoom, YouTube channels where people can just record their statements and it's played to the other side, and the other side can be able to also respond to it? How can you even say sorry using a song? So this is the platform that you're telling Kenyans. We are promoting multiple doors of accessing justice and thinking outside the box using the media platforms. We are having this webinar. We are able to reach 120 people. If we were to have it physically, we'll have cost of even accessing the webinar, the physical space. We'll have cost of hosting people, the cost of even hiring the hall. But now we are reaching 220 people through a webinar. This tells us that even justice can easily be achieved through an online platform. And we are thinking outside the box. The reason why now courts have gone online, using virtual sessions, it has enabled us to be able to meet clients in Turkana, meet clients in Mandera, meet clients in Kajiado. And so using the online platforms, we'll be able to not only promote the use of ICT, but we'll also be dealing with so many hurdles that people face in terms of accessing justice. I'll just use one example of a woman who is a person who sells vegetables in a market, groceries, or a hawker. This woman has a matter in court. let's say she lives in Babadogo. She's supposed to come all the way to Kibera. So she has to leave Babadogo at 5 because of the cost of transport, comes to Kibera. Has to stay in Kibera wait until 9 when the court starts, and maybe she's told the court starts at 10. Then at 10, the court has to go through a court list of 30 matters. By the time the matter is reached, it's like 2 or 3. So you find that this woman, first of all, has stayed in court the whole day since 5 in the morning. You left your child with a neighbor to take care of that, your child. You're not able to go to buy your stock to be able to replenish your stock so that you can come and sell to your clients. You're not able to now do your business that particular day to get the little income of 100, 200 shillings to feed your family. You come back home, there's traffic. By the time you're getting back home, it's around 6 in the evening. Maybe the matter did not proceed. So by just a click of the button, if it was to be resolved through alternative ways and through this media platform, you just click the button, a phone call away, a WhatsApp message, WhatsApp video call, we're able to resolve the dispute within our space, 5 minutes. You're told, okay, yeah, you did not manage to complete, can we have a session tomorrow? So I say, yeah, tomorrow you still have your session within just your space.
Okay, picking from where Adelaide left, I know most of our viewers would be wondering about certain. You getting me?
Yes, we get you. However, Ms. Aluda was speaking, but it seems Ms. Aluda, you're breaking.
Yeah, I was speaking, but yeah, I was speaking. Yeah, so I was saying most people can be able to reach out through the online platforms. The students, sorry, the youth population, now they're thinking about online, and you're telling them to go to court. So it's an opportunity that they can have to resolve their disputes, and even innovatively come up with platforms that people can engage through social media and online platform. Yeah, thank you.
Thank you. Mr. Gordon?
Yes, Mr. Luda, when you talk about alternative justice, most people would be asking, what kind of justice is this? What type of justice is this? What forms of justice is this? You and I perhaps know that when you talk about justice, you'll be talking about procedural, you'll be talking about retributive, you'll be talking about restorative. So exactly what kind of justice do we expect to access or dispense by way of alternative justice system? And secondly, we have alternative justice system or institutions. We have Court Next, we have ABCD. Would, for example, the online platforms like or radio platforms like Radio Jambo or the Patanisho Show be part of an institution that can be used to access and dispense alternative justice?
Okay, thank you very much. So first of all, alternative justice system, we look at people-centered justice, we look at the community-centered justice, we look at the culture that people have been able to, which is the dynamic, develop and say, this is the way justice that we think will work for us as a community. So we are looking at the restorative justice because we are not looking at the procedures of propriety of going to court and being told to file papers. We're looking at what is the basic minimum natural rules of natural justice that is required for you to be able to say that justice has been dispensed with. We're looking at parties coming together like what Joy has explained. And when parties come together, can they be given the opportunity to be heard, the right to be heard, opportunity to be heard, opportunity to bring maybe 1 or 2 witnesses, so that at least people can be able to say that I effectively participated in the system, and whatever outcome came in, I can actually adhere to it and say, yes, this is the justice that we want, and that is actually the outcome that we were expecting. For a very long time, for instance, in criminal trials, somebody is caught red-handed, maybe stealing, caught red-handed, has committed a crime of assault, but when they go to court, the first thing they say, it's not guilty. But through alternative justice, when parties actually meet and you are asked a question, you actually say that, yes, I did this and I'm ready to be able to do right that which I did wrong. For instance, take care of the medical expenses of the person that you've assaulted. If it is stealing, you're ready to compensate the person. If it's an issue of trespass, maybe your cows have gone and stepped into somebody's shamba and destroyed crops, you are ready to say, yes, when I harvest, I'll be able to pay back this number of bags of maize. Yeah. So that's the kind of justice we're talking about. We're talking about a justice system where people actually are ready to acknowledge their wrongs, acknowledge what they've done is wrong, and be able to make right that which is wrong, that which they did wrong. In terms of the systems and institutions, we're talking about innovations. Actually, that is the social transformation through access to justice. It's about us thinking outside the box. How can we transform our mindset in getting justice? And I'm so glad with the platform that Gidi is providing, the Patanisho platform, that people are thinking of how can I use the radio to be able to, Gidi is saying, can we use the radio channel for people to come together and be able to deal with a justice question? Can communities sit together and say, we have a problem of alcohol? Instead of people being arrested and taken to court, can the community sit down and say, can we address this problem as a community? We have a problem of succession. Can the community sit down and say, what can we do to deal with succession matters so that people do not lose their properties, families are not disinherited? What can we do as a community? So we're looking at community-centered justice, community sitting together and coming up with solutions that are going to benefit the whole community. Lastly, in terms of innovation, we find that the court system, we are still stuck to the penal code. We are still stuck to the civil procedure, the kind of outcomes that we get from these processes. But in innovation, in alternative justice system or community-centered justice, we are innovative even in the outcomes. Kama ng'ombe yako imekula imevuka kwa shamba ya mwingine na ikala mimea, you are given an opportunity that hii mimea tumeweza kuvalue in the next when you harvest, you are supposed to give 2-3 bags, but when you come to court, utashikwa, uingizwe ndani, ukae ndani, uweze kupewa maybe fine, you are not able to pay this fine. So there is no innovation because the court is the penal code is telling you this is the punishment for this particular offense. Yeah. Thank you.
Maybe lastly, so that
Sorry,
we don't
so
lose
in terms
track.
of the, yeah, sorry. I'm sorry.
So that we don't lose track on this. The interaction between AJS and the judiciary. For instance, let's say we are taking Patanisho Radio Jambo as one of the actors and one of the institutions that will dispense alternative justice system. Would there be an interaction, and what kind of interaction it would have with the judiciary, such that an agreement reached in Patanisho can be formalized in some kind of a way that is recognizable?
Thank you very much. If you look at Article 159, 2C of the Constitution, it tells the judiciary to promote alternative dispute resolution mechanisms, traditional dispute resolution mechanisms, and other forms of justice systems. And that's why our Chief Justice has come up with this platform justice. So before this, in terms of hierarchy of laws, we were being told to look at the Constitution, the written laws, statutes, the precedents from the courts, then the issues of England. So customary justice, or the way of people's justice, was actually at the bottom. But if you look at Article 159 to see what it has told the judiciary is, as you look at the formal court system, you also have a role at the same lens, at the same level. So it's like your eyes must also be focusing on what is happening outside the court system. So what are the now mechanisms that we are advocating the courts to do? So the courts are now partnering with other justice actors in terms of bringing them on board as partners, bring them on board as also players, bring them on board not as spectators, but also as important stakeholders in terms of justice. So the court is being advised to be able to deal with the traditional mechanisms, with be able to deal with the CSOs who are dealing with disputes, Can you also be able to look at now people like the platforms that you have like Radio Jambo? Can you look at any innovations within your court premises, within your CUC that you can be able to tap in? So how do we deal with it? We deal with it by having now the court annex AJS mechanisms. So the court is looking at what are the mechanisms that are existing in my community. Are they the community-based? Are they the civil society-based? And we have the chiefs who have the policies and the documents that we can be able to operationalize within the court. Then now court taps into them and promotes these other mechanisms to be able to handle with disputes. So in this way, the court is appreciating that it's multiple door approach. There are other doors other than the court, and the court is bringing all the stakeholders together to be able to work with them in terms of justice. So this platform like Radio Jambo becomes a very effective tool to be able to deal with justice gap within the community. Thank you.
Thank you so much for that, Ms. Jemima. Very elaborate. You said not only just in innovative systems, but innovative solutions. That is what we are seeking. Yeah? If we can resolve a matter, Radio Jambo takes 30 minutes. Believe 30 minutes. You know, why are we wasting 30 years? So thank you so much for that. I see that we continue. We are still having people asking questions in the chat box. People are raising their hands. So we shall slot a time for you guys to, be able to raise your hands and directly speak to the speakers. Alternatively, speakers, as you continue, even if I ask you a question, you can look at the question and decide to incorporate the answer in your submission. Now, you have talked of, a person can join from the comfort maybe of their bed when a mediation session is ongoing. Now I pose this question to Joy. Joy, do you think that online media platforms, they disadvantage the mediation process? Because in mediation, you take a lot of factors into consideration. So like nonverbal cues, I might say something, the other person flinches. This might be a very emotional topic. And because I cannot see the other person, and maybe the tone of that person might not hint that this is an emotional topic, I can just overlook that part. So, Joy, do you think that in a way, online platforms, in as much as they're advantageous, they take away the meaning of mediation, which is to foster relationships, to build rapport among two conflicting parties?
Thank you very much for that question. I'm really enjoying the conversation. And again, when it comes to mediation, mediation has principles within which it should operate. Yeah. So online mediation is an innovation in itself in terms of making sure that you access parties, right? So I think, and definitely with every innovation would come some challenges, right? So the question we're asking is how, for example, as you've given, how do you factor nonverbal cues when you're doing online mediation? And what, some of those things can be lost in between, but I think instead of posing it as a challenge that cannot be solved, again, we go back to what Madam Jemima has talked about, which is innovation. How then, what can we come up with? What tools can we come up with to ensure these kind of things are factored? For example, if you're doing an online mediation, say on Zoom, you can definitely ask the parties to put on your videos. You can ask the parties that want to see you. It may not be as hands-on as an in-person mediation, but the idea is that these two people are still getting what they need. Again, mediation is party-centered. So it's not for you as the mediator to make sure that you police the parties. The parties want to resolve. That's why they are before you. So again, they also have a responsibility in making sure that they talk about what it is that brought them to the mediation. So that's the beauty, I think, about mediation. It is party-centered. So I think there's a lot of room for innovation, even as we now have online modes of doing dispute resolution. For example, there are people who are actually, I've not really tested it out myself, but who are mediating on email. So I'm not seeing you, but the mediator is reading through the email trail, the responses are coming through. at the end of the day, if that is the system that the parties have chosen and they get what they want, then I don't see the problem, provided that the very foundational principles of mediation, again, are not violated. So I think we should keep, as we innovate, we keep improving the platforms. A good example is when the courts rolled out the virtual courts, right? Today, this is how many years later? This is about 2-3 years later, and it keeps improving every time. So it quite doesn't get there instantly, but it will keep improving. So the question we need to ask ourselves, how do we mitigate some of those challenges that come about, instead of saying, let's not do this, no, this is sensitive, let's not discuss it online. I mean, let's discuss it and see how can we mitigate some of these challenges. Yeah, so that's what I'll say towards using virtual platforms. It is possible. People mediate, even at very high level, mediations are happening virtually. Online dispute resolution is actually a big thing. Yeah. Yeah.
Okay. I need to add something. So tomorrow, the Chief Justice will be launching the Uasin Gishu Alternative Justice Systems County Action Plan. And it's the first county action plan that we are going to have a virtual launch with other sub-counties. So we'll have virtual launches in other sub-counties. Actually, the way the model is, it's a devolved model. So we have you can be an AJS practitioner, like an elder in Moiben, and you want to resolve a dispute between parties who are in cases. One party is in cases sub-county, another party is in Turbo sub-county. So we link you up in a virtual platform so that wherever you are with your expertise, you can be able to handle the matters between these two parties who are in different spaces. And then you are linked to now a secretariat within the court premises who will be able to guide the process. So that's now the greatest innovation justice here in Uasin Gishu. So it just shows the way we need to innovate, so that you're not sitting down with maybe an AJS practitioner or a mediator in one space, but Joy in Nairobi can be able to, we can link Joy with somebody who is having a dispute in one area, for instance, in Eldoret. Another person has a dispute in this part of the country, but now they want the expertise of Joy, and Joy doesn't necessarily need to have the parties sit together. Then there's somebody who is coordinating that particular session. So this is the kind of innovation that we want, the way outside thinking that we want people to have. For instance, you have a dispute that requires an expert who has an understanding about the Muslim way of doing things. We can link you up with somebody who is in Mandera, but you are here in Uasin Gishu. Then the person can be able to assist you to deal with that.
Thank you, Madam Jemima. Let me just add something on innovation and draw it back to our constitution. The preamble of our constitution says, "We the people of Kenya," right? And then tying that into, am I audible?
Yes, you are.
Oh, okay. Sorry, I think my screen froze at some point. Yes, so it actually, our constitution gives power to the people. And every time I read this constitution, I get so happy, because it's like they envisioned that the power to do even innovation belongs to the people. If you look at all these traditional ways of resolving disputes, these are people who sat down years ago and devised that this is how conflicts can be resolved, right? So if we give power back to the people, the likelihood of them innovating different ways of that you absolutely cannot think about at the moment would be really good. As we look at even with the things like TikTok, I want to see an opportunity where you'd actually have chats, where you can resolve disputes with somebody that you're talking to, the likes of now Patanisho. I think the opportunity to innovate is greater than even the challenges posed by those very innovations. So I think, yeah, that's what I can say. Yeah.
Thank you so much, Joy, for that. Well, you've talked about your TikTok, especially I think we have very young people as our audience today. You guys, the way we have podcasts, instead of having podcasts to discuss Oh, fashion trend. Oh, we can have podcasts that are driven towards dispute resolution. So, thank you for that. Now I move on to Ghost. I understand Giddy had joined us, but it seems he is not around. Either way, when he rejoins, we shall have him on the platform. So Ghost, the way we have spoken, yeah, using online platforms, do you think that now that we have legal practitioners and Joy, Mr. Gordon, and they're telling us about alternative justice systems, that we have court annex mediations, you do not have to go to court, do you think that there's a way radio platforms can be used to disseminate this information to, us common Mwananchis? Because some people might actually only think that binding decisions only come from the court, but you see that you can pursue mediation and it has a binding effect to the parties. So do you think that radio can collaborate with legal institutions, with organizations to ensure that justice is served to the people?
Well, thank you. First of all, people have to understand that radio is very powerful. And mostly the common mwananchi is the one who has issues concerning the law. And it is the easiest way that we can get people to know maybe the legality of the matters that they want maybe to resolve. And when we have a legal person, that actually sorts the whole problem about legality, because we have had in most of the patanisho that what actually happens is about somebody who has left their wife with the kids, and then we have had problems like, I'm not going to support the kids. If she wants, she has to bring the kids to me. I'm the father. If she cannot support them, they have to. So there's a legal aspect, and that is why we need normally that legal part of radio. It really helps to do the patanisho, but always had that aspect of the legality of it. And if we involve the legal practitioners in this, then that can be able to sort a lot of problems. And we have also had, apart from those conflicts about marriage and relationship, the most important item again is about land disputes. Nasikia shamba, mzee alinitoa, tuko vijana wanne, alipatia watatu, akaniacha mimi peke yangu. Now you find that the old man decides on his own, but what does the law say? So that is why when we add that legal aspect to a program like Patanisho, then it can solve a lot of problems. I'm also happy because the example that was given by Aluda, people don't have to travel so far, waste time, waste money. When we do it like we are doing right now, it solves a lot of problem. Right now, we are having around 112 people attending at the same place and at convenience of your place. And I think this is a new way that we should be able to resolve most of these conflicts.
Thank you so
maybe
much.
I just want to add, I want to add something about the issue of the radio.
Yeah.
So if we can be able to collaborate, how do you collaborate? We have people who have resolved this, for instance, land dispute, coming to tell through the radio platform, and they inform the people, this is how we've done it. So people in other places will learn and say, oh, by the way, these platforms exist. I have learned that actually we can sit together and handle this matter in this manner. Can we start our own way? So it encourages that kind of innovation, even in other communities. Then also communities will learn how disputes are resolved in Mombasa, the difference on using the Kaya elders, the Kaya platforms, with the Kipka platforms like in Wasingishu, with the mediation, how do mediators deal with this? So we use the radio to be able to spread, to cascade that information and also learn from each other. The people also learn about Mandera. So I think that radio platform, especially there are those platforms that have a wide reach, like Radio Jambo. If we can be able to use those platforms to showcase how disputes have been resolved and telling people, let's embrace these other ways of dealing with disputes rather than court processes, then we'll be able to deal with the justice gap that we're experiencing in our country. Lastly, in terms of innovation, here in Wasingishu, I'm currently in Wasingishu, people are using like theater, and they're saying before we train you about AJS, we do some theater some maybe it's a skit on a dispute, it's a poem on a, or some song, some sort of a song. So once people use these platforms to be able to showcase how a dispute is handled, even a land dispute, then others say, oh, by then, even as you train, then this is how we should be able to deal with this. So we want that kind of innovation, and the youth play a big role in terms of the dealing with innovations. Thank you.
Thank you so much, Jemima. I see Joy has raised her hand. So Joy, could you just comment briefly so that
Yes. Yes, I know
Mhm.
time is not on our side, but I also want to comment because how can we use the reach that radio already has, you know, to disseminate some of this information. And one of the ways we can do this is also by talking about what have been the gains of these alternative justice systems. Because if you look at statistics speak for themselves. A survey was done, and it was a while back, and I'm sure the statistics would even speak more today, is that 10% of the disputes are the ones that go to court. Yet we still have backlogs in courts. So it begs the question, 90%, where does it go? Who is resolving the 90%? And this is the alternative justice space, the multi-justice space that we're talking about, that is handling the 90%. So what is making it so successful? You know, those are the questions we need to ask ourselves. Talking about the wins of mediation. If you look at today, mediation has unlocked so much money back into our economy. Money that was stuck in businesses, money that was stuck in debt, money that was held up in disputes. And really talking about those statistics would actually show people how much this it's resolved. Right now, the settlement rate of mediation it stands at around 50 something percent. It's about 57%. That is between January and April of 2024. What does that tell you? Like, anything that goes to mediation, it has a higher likelihood of actually succeeding, you know. And I believe the story is the same with the other AJS platforms. So if we tell people the truth that these alternative ways are successful, these alternative ways are good for you, let's talk about the benefits. What do you stand to gain from this? How would you salvage your relationship? And I think that would become a very good selling point that we can talk about all across our radio platform, so that somebody knows that I don't have to go to court to resolve my dispute. I can go to the Nyumba Kumi. I can go to because AJS even has the religious leaders. I can go to the person next to me, and I'll be able to get my dispute resolved, and I can be able to move on. Yeah. So that there's a lot of work we need to do on awareness creation when it comes to mediation and all these multi-justice systems we're talking about. Yeah.
Thank you so much, Joy, for that. Maybe to go back to Miss Jemima, you've stated the link. Tomorrow there was an issue, action plan that is being launched. So if you could please also share the link our chat box so that people can, access it, so that we can be able to attend tomorrow. And now we are moving on to the Q&A session. And I see that Martha Musimbi has raised her hand. However, Martha, let me just pose this question that had already been asked from what Ghost was actually saying. So Ghost, you were telling us, you have people, criminal matters, people come, they tell you, oh, this is what is happening. For example, that case that happened 10 years ago. There's a question that has been posed in the chat box by Edeli Marangachi. So Edeli says, thank you for this great session. My question goes to Gidi. Well, Gidi is not here, so Ghost, you shall take this. Now, do you report crime matters to the relevant authorities when you find them during your patanisho? Or you wait for police to see and hear for themselves and come for those who are involved in those offenses? So are you the guys who take the first step? Police come to you guys first?
Well, we just wait until the police come, but what we do, everything that we do is recorded. So if they need any evidence, we have it ready.
Oh, okay. Is that a way of protecting your audience? This is that confidentiality so that they can trust you guys more, or it's
Well, because we already it's a voluntary kind of a session, and we are not there to be reporting. It is the duty of the police and the justice system to follow up on matters. Like I told you, the case that the patanisho was going on and the police were listening to it. They came for the evidence and we gave them whatever they needed. But it is not our work to take such cases to the police.
Okay, thank you so much. I see we have Martha Musimbi will take your question, followed by Ianson Chilai, in that order. And please, may your question be brief and to the point, and you can direct it to the panelist you want to answer that question. Okay, if Martha is not, maybe we can have Chilai. Martha or Chilai. Okay. Okay. Is there a problem? Why are they not speaking? Okay. Before they speak, maybe we can move on to the questions that have
Can I
posed.
be heard now?
Oh, yes, fantastic. You can be heard. You may go ahead.
Yes, thank you. I think there was a problem with the settings previously. I couldn't. Yes, thank you for this session. My question will be very brief. I was asking in relation to the AJS. I strongly support any alternative dispute resolution mechanism. However, from a legal perspective, I'm just wondering, yes, I do understand that the elders used to resolve issues even back then up until now, but I'm wondering which measures are the courts taking when it comes to them being involved with matters, but then they still are somehow resolving with them in a manner that is repugnant to justice and morality, or maybe discriminative, because maybe as per their culture, that is how things are. Yes, because now the court will not be there to monitor and say, now, the law says this and your culture says this. It's now a way to encourage the traditional mechanisms of resolving issues. And sometimes they can actually be discriminative or even repugnant to justice and morality. But that's just their way of life, which is acceptable as per their culture.
Wow, fantastic question. Maybe we can have Joy take that. Joy,
And maybe one more. I'm sorry. Maybe one more last question. Are there any trainings that are given to these elders in as much as they've been historically involved in dispute resolution, or it's just automatic? Okay, thank you.
Okay. Can I answer that?
Okay, yeah, yes, you can.
Oh, sorry, it was yours. Yeah, please go ahead.
No, I think maybe let me just touch on the first part and then I can allow you to say, because I think AJS is actually the one leading the team. What I'll say from my interaction also with AJS is that, first of all, our constitution and Article 153 again says that traditional justice systems are being promoted, provided that they're not repugnant to justice and morality. And what AJS, I know they are doing, and I know Madam Jemima can talk more about this, is that there's a lot of training going on for AJS practitioners. And this include for elders, all those people who are saying that they are resolving disputes in their different communities. That training is available for them to also, so that as they resolve using what they know, their norms, their cultures, their traditions, they are able to benchmark against the Constitution to ensure that they don't violate the very principles that the Constitution is trying to promote, like discrimination, and that their operations are well within the law, right? So that is really happening a lot. And so I think we've only scratched the surface, but I know Madam Jemima will give even more statistics of how much they've been able to cover in that. And as a mediation trainer, what I'll say is, when we train community mediators, for example, these are things that we bring to their attention to make sure that as we are promoting what they are doing, we are also informing them on what is there, so that they, put the two together and be able to deliver that very justice that the parties seek to have. Thank you.
Thank you so much, Joy. Indeed, you've covered quite a bit in terms of that question. We are doing a lot of training, sensitization, awareness creation about the constitutional values and principles of that are required under Article 10 of the national values, the issues of involvement of the minorities, involvement of the marginalized communities, the issue of the vulnerable groups. However, let's go back and ask ourselves, whose justice are we looking at? For the colonials, what they found us doing, they thought it was repugnant to justice and morality. What is that we have to address is not what the colonial mindset had in terms of this is repugnant to justice and morality. What we need to address ourselves is it within the framework of the human rights that we've been provided for under the Bill of Rights in the Constitution? So what we are doing is training the elders. And who is an elder? The elder is not those old people that you think about. Joy is an elder by virtue of her being a mediator, by virtue of her being able to handle a dispute. You are a mediator. Adelaide is a mediator by virtue of her status in the society in terms of Kabarak being a student leader. She's an elder. So what we are doing is working with these different platforms that we have to be able to create awareness about the human rights framework, constitutional values, and trainings. Number 2, we are developing county action plans in all counties. So far we've done 12, although we are now launching the 6th one. We are advocating through these county action plans, we are seeing modalities which now the practitioners, the elders, the mediators, all these multiple doors that we have can be able to work with the court, and the court can play its role of oversighting that Bill of Rights are respected, people are facing, I'll be able to be addressed. Thank you. Back to you, Adelaide.
Thank you so much for that, Jemima. I was just looking through the chat box and we have very interesting comments. This one I would like to pose to my fellow moderator, Mr. Gordon, because of his expertise, just to coalesce 2 questions. So first, how enforceable are decisions that come from ADR? So for example, people go for mediation, are those decisions enforceable? What Ms. Jemima is speaking about, if we go do with the chief elders, can I come back and hold someone accountable because of what the elders have said? And then I also have another question. The second question, still to Mr. Gordon from Barak Onyango, is, Barak, first of all, has thanked you, panelists, and he's asking that, previously we knew that criminal matters were not to be taken to ADR until a shocking jurisprudence of R versus Mohammed in 2013. Therefore, criminal matters are not a limitation to the use of ADR. Then what are some of the limits to the application of ADR? So those 2 questions. First, so first, what is the extent that we can use ADR in criminal matters? And second, the enforceability of decisions that arise from alternative dispute resolution mechanisms. So Saji, I would love for you to answer that. And then after you answer,
I would have been very happy to throw it first to Joy. Being a moderator, I would want to give her the airtime first.
It's okay.
Okay, let me answer the question on enforceability, and maybe a bit on the including criminal whatever justice. I think the first thing to note is that there's a lot being done, because after 2010, a lot has been happening to try and make these processes formal, because they had been sidelined as informal, as the so-called repugnant. Now there was deliberate action in now mainstreaming them into our laws. If you look at today, we have the mediation guidelines, right? The mediation guidelines provide that you can actually have a mediation settlement agreement that has been reached privately, that is not even court annexed, and you file it in court for them to actually adopt it as an order of the court. What does this tell you? That whatever you're doing there is acceptable. So, and if you come up with, of course, if it's court annexed, you normally report back to court with whatever settlement that has been reached, and it's adopted as an order of the court. Moving forward, if the parties are looking at if the parties violate any of terms of those agreements, it is like you are disdaining an order of the court, right? So the courts have basically, or the laws are now being aligned to make sure that whatever is being agreed upon out there can be brought back, okay? Can be brought back for or recognized as enforceable. But also, one thing that my experience with also alternative dispute resolution mechanisms, especially mediation, you find that because the parties participated in coming up with those solutions, it is very highly unlikely that they would go back on their own word, you know, because they agreed, they came up with something that is doable for them, is feasible for them. So you find that they are more keen on agreeing. And in the event that, say, maybe one of the terms of the agreement they're not able to sustain, they would come back to the table and review the same. Yeah, so that's what I can say about the different dispute resolution mechanisms and how they can be mainstreamed, right? I've just given an example of mediation, but also for AJS, it's the same. When you look at arbitration, it's the same. And that's why you find that a lot of these dispute resolution mechanisms, the decisions that are arrived at are normally not appealable because of the weight they carry. It is the people themselves who've decided. Now, when you come to talk about the second thing on criminal, again, I'll go back to what Madam Jemima asked, whose justice are we talking about? You know, so if we had placed limits on how far ADR can go, whose justice are we talking about, right? I'm looking at a scenario where maybe somebody's property has been stolen, right? And it goes through a criminal process in a court of law. The court finds the perpetrator, the accused person guilty of committing the crime. It does not bring back the items that were lost. You see, so was justice really served? And those are the things we need to decolonize the term justice, right? And so even having such a jurisprudence that, like that one that was in 2013, opened the floodgates for such things to be done. Today, you'd go to a criminal court. In fact, I actually had a matter not so long ago that actually went through the criminal justice system, but in the middle, it took so long. It was going now to 2 years, and we had to sit the parties down and have a conversation, and they actually got to a settlement. And the person who was the accused person actually got an opportunity to say, I am sorry, I actually did this, and they were able to compensate, you know, the victim for what had been taken from them. And so we cannot put like barricades to these things. Of course, there are some of the things when you talk about sexual, when you talk about sexual offenses like defilement. So there are those confines that are still being guarded by the judiciary that are only a preserve of the courts for various reasons. And I think it's mainly because we have not yet gotten to the point where there are mechanisms to ensure that these matters would be handled with a lot of care. For example, matters concerning children, looking at how much you have to really care for the best interest of the child, especially when it comes to child abuse. Hope I've answered that sufficiently. Thank you.
Yeah, that's answered sufficiently. I think the only difference between a settlement coming from a court annexed mediation and a settlement coming from any other mediation is that a settlement from a court annexed mediation automatically becomes an order of the court, whereas the one from any other mediation that is not sanctioned by the court is an agreement that can be enforceable in the sense that if, for example, one of the parties breaches the terms of the agreement that was reached in a mediation, the offended party may move the court to have it enforced like any other contract. And,
okay, so Gordon, maybe to address that. So now we are in terms of innovation and in terms of the law, the judiciary have said, and Article 159 to see, it's not just to look at what is within the court. So even in mediation, the platforms you are coming up with is once people have been able to have a mediation outside the court, can they also come and it being registered in the court? Even in AJS, we are also encouraging parties, once parties have a dispute, can they also come in the AJS suites? We are opening AJS suites. We call them Ukumbi suites, Masla centers, AJS centers. Can they come and have practitioners hear their matters, and it's actually an outcome is given within that platform and is registered as an order of the court. So that's the innovation we're coming up with, not just waiting for that which the judiciary has said you filed in court, then parties have agreed in court. No, can the judiciary play its role in terms of promoting alternative justice systems by also addressing those disputes that have been solved outside court? So those are the innovations that we're coming up with and the platforms we're coming up with. Thank you.
Thank you so much. We shall take like 3 questions and then we can move on to concluding the session.
Adelaide, as that is happening, maybe you can share the mediation rules 2023 where you actually can see how to take a private mediation settlement to court, you know, for recognition, yeah, and enforcement, yeah.
Okay. Sawa. Ianson Chilai has raised his hand for a long time. Chilai, please, you have the floor.
Okay, good afternoon.
Good afternoon.
So I'll try to be brief as possible. So I have 2 kind of questions. One, as the panelists were speaking, I realized we were only focusing, let's say, on the good side of the AGS. Now my question is, in instances of, let's say, bias or potential discrimination within these AGS systems, how do they affect their fairness, and what legal measures can we ensure these systems remain impartial and uphold the constitutional rights that we have provided? Then my second question goes to Mr. Mule, the Patanisho program presenter. Now my question is, do you guys have, let's say, immunity? For example, if you misquote someone or present a false information about someone that can ruin their reputation, that could amount to defamation. Like, do you have that certainty of information, or do you have that immunity? Thank you so much.
Thank you, Chilai. We can have the first question answered by Ms. Jemima and the second question by Ghost.
Sorry, maybe Joy can be able to answer because I had a challenge with network a little bit. Joy?
Yes, I can answer, but I missed out on a certain point. Maybe he could just there's a point he was actually breaking as well on my end. So could he kindly just, yeah.
Okay.
Lanson, you talked about
was
something to do with the bad parts and impartiality. That's all I had.
Yes. Okay, my question was, in this discussion, I have failed to grasp, you have not talked about the bad side of the AGS systems. Now my question was, in instances of, let's say, bias and potential discrimination within the AGS systems, how do these instances affect their fairness, and what legal measures can be taken to ensure that these systems remain impartial and uphold the constitutional rights we have provided? That is my question.
Okay, thank you. Jay, maybe I can start. So one of the disadvantages or one of the challenges we have is maybe in mixed communities. For instance, in the Muslim area, in Mandera, they wish to apply Matla system. Now you find there are people who are not Muslims, and they're living in Mandera, so they not be able to even appreciate how that Masla system is applicable to them. Yet it's supposed to be applied between Muslim and Muslim. We see also this the matter that was in Saudi Arabia. I think it was in the public domain where the Kenyan was asked to pay about $500 million as part of the Masla system, failure of which you're supposed to be hanged. So it becomes a challenge when you apply such kind of systems, especially to communities that don't advocate to that culture. We also find this challenge even in the Maasais, whereby they say that among the Maasais, ukiwa Maasai, lazima ulipe, lakini ukiua mtu mwingine huyo si mtu. So it's also one of the disadvantages that we have in application of AJS. So it becomes a challenge where we have mixed communities, mixed cultures, mixed way of doing things. And how do we advocate for it? We advocate for now inclusion. We advocate for them now to apply for human rights standards, like as I had mentioned about the constitutional values. We advocate for them to be able to apply inclusion, especially for women, like the systems whereby still women are not allowed to sit as elders. So we've been gradually advocating for inclusion of women. Joy?
Yes, I
Maybe
think
maybe just to interject on that one. I think if I hear Shilai correctly, is asking like what would happen if there's a question of biasness or whatever. If you look at the AJS task force policy, you'd find the principles of difference where, for instance, if there is any procedural issues or correctness of at AJS proceedings, then there is a proposal that that kind of proceedings or award could be subjected to review by the courts. I don't know if that is already working, Jemima.
Mr. Jemima seems she's facing technical issues. I think we can move on to the question that was posed to Ghost with regards to defamation. Do we have, is there a possibility that a person can come and say things that are not true about a person on the station? And has that happened before? Has there been a court, a legal matter? Okay, has it been sued? Has it been taken to court?
Thank you for that question. First of all, we normally announce that this is a radio family show whereby families are listening. So we warn our listeners, the people who bring such dispute, we warn them about the language that you're going to use. You don't use foul language. And if you do, immediately we stop and apologize, maybe to the party that has been aggrieved. And we warn that if you continue using such language, then we are going to disconnect. We take precaution in that. We try to protect everybody to use language that is respectful. Secondly, we have radio laws that we are told that this is supposed to happen. And when somebody maybe becomes uncontrollable, we just disconnect the phone call. We don't continue with the pattern issue. We have had incidences and not something that we've never been sued by anybody. Nobody has ever gone to court because of defamation. But we normally warn the people who are being reconciled that they have to have some language that is acceptable.
Okay, thank you. Thank you for that. Additionally, in light of that, we have a comment by Charles Obulutsa, who is a chief magistrate based in Kericho and an ardent listener of Gidi and Ghost in Patanisho. He says that, through listening through your shows, he is able to use your approach in resolving disputes himself. And out of 10 cases, he is able to resolve an average of 6 cases. So,
Wow.
yeah, he says good work, by the way, good work, all panelists, and good work to Gidi and Ghost. So you see that your work is really impacting people more than the judicial system, let me say. So good work to you. And
well, we appreciate.
Adelaide,
yes,
there was the question on impartiality. Let me just comment on it very briefly from a mediation perspective. Definitely,
okay.
Question of impartiality, that is an ethical question where you have ethical guidelines that govern mediators, whether you're operating privately, whether you're operating within the court annexed system. The standard is cut across, right? Because from the training that you receive, because a professional mediator is normally trained, so from the training you receive, there's a way in which you should conduct yourself. Now, in case of an issue, for example, if you've gone through a court annexed mediation and there's an issue of impartiality that has come up, normally the parties, there's avenues that the court has provided for you to actually lodge such a complaint for that mediator to be dealt with. They would probably maybe shift the mediator or give a warning. So they have, at least there's a reporting mechanism. Again, these are developing things, so a lot is being done. For example, as Amani Communities Africa, one of the things we are constantly doing is building the capacities of already certified mediators to make sure that we just make sure we keep letting them know that, about these ethical issues and how they would undermine a mediation process, because if a mediator fails to be impartial, then you can imagine the kind of effect that would have on the parties. So those are some of the mechanisms I could say. And a party at every moment in a mediation has a right to terminate the mediation should they feel that those principles of impartiality, fairness are not being upheld. So that's what I can say on that. Yeah.
Okay, we have come to the conclusion of this session. I shall give, first of all, I shall just give the last questions. Should I not raise your questions? It is because it has been answered through them answering other questions. So I shall give each panelist an opportunity to answer one question and also give their concluding remarks. Okay, my first one goes to Ms. Jemima. So the first question is, how can one train as an AJS practitioner, and what are the requirements? This question has been posed by Edily. There's also, just to join that question, there has been a question by Ruth Juliet. She thanks you, and she raises a concern whether the Judiciary AJS Committee has provided guidelines for cases of abuse against children and other vulnerable members of the society. The second, moving on to Joy, your last question is one posed by Marian Machuka. Marian is asking, is it correct to say that the multi-justice system can provide a loophole for solidifying issues that are gaps in the written law of Kenya, for example, LGBTQ matters? So can we have ADR, listen to matters, or like, for example, LGBTQ matters? And a question to Ghost that, and this just refers to the question that had been asked, what happens when audiences but I believe you've addressed this, when audiences give wrong information about other people, which soils their image? But I believe you've seen that immediately that starts happening, you stop them. Are there instances where you've been forced to, kick out people because they do not adhere to these guidelines? Have there been instances where, it's been unsuccessful because people are not cooperating? And if you listen to a matter today, is it possible that tomorrow, you listen to the same matter like IJ Shabado, so we have a part 2. If you want to listen to part 2, come tomorrow. Have there been such instances? So it's like a backlog of cases. Okay, so let's have everyone take those questions, and then you can, as you're answering your question, you please give your concluding remarks. So we start with Joy, then to Miss Jemima, finally to Ghost. Thank you.
Okay, so very briefly, thank you for that question. Can alternative justice system, or this multi-door approach we are talking about, be used to solve some of the things that have legal loopholes, or like are a legal loophole such that the conflict is not necessarily having like a legal context? Absolutely. And I think that is the opportunity and the innovation that lies in all these MJS, multi-justice systems that we're talking about, where you're actually, things like having a conversation with parties to try and see whether they can say sorry, things like that. Like to address the power of apology, address some of the power dynamics. Those are not necessarily things that you can bring up in a court of law or in a formal justice system. So they definitely offer the opportunity to handle such loopholes. But there's an exception to, of course, now you asked a question, for example, like about LGBTQ and everything. Definitely these are people and they have normal conflicts. So as long as whatever agreements that are being reached, if it's going to be written in an agreement, need to, of course, have, they need not to be illegal, right? But if it is anything social, and especially I call them non-substantive, but they are the things that actually blow the substantive things out of proportion. For example, in a succession, it could boil down to a simple thing like sibling rivalry, which the court would not have the time to address. They would only be looking at how do we resolve these disputes. So in that to that extent, they do offer a platform to resolve those things. Now, to my parting shot or ending, I just want to say that we need to redefine what justice is, right? We need to decolonize what justice means. We need to have people at the center of what justice is for them, right? We need to make it accessible. We need to simplify what justice is. And certainly, we definitely need to advocate for all this multi-justice approach and encourage innovation around the same to make sure that one, the 90% of the disputes that don't go to court are resolved because conflict happens in our daily lives. And number two, to also help the judiciary in resolving the backlog that they have even with the 10%. So I would encourage all of us to try and think, and also with the information you've gathered from this particular platform today, go and tell a friend to tell a friend, and let's be agents of change to that extent. And I believe our society will be socially transformed for the better. Thank you very much.
Wow, wow, wow. Makofi, thank you so much. That's a powerful parting shot. Young people, please use your platforms, yeah? Come up with innovative solutions. Let us decolonize what justice means. Thank you so much for that, Joy. It has been a pleasure to host you. Let us move on to Ms. Jemima. Okay, I see that there's a possibility that she's not in the meeting. Before she comes back, maybe we can move to Ghost. You could answer your question and give us your parting shot.
Well, I think first of all, I have to say that it's been a very nice session. And to say that language is very important. Why we have patanisho is our joy is when two people have differences and they want to be reconciled. Our joy is when it ends up well. Sometimes it might start with a very high pitch. Somebody is very mad, and then when the other party talks, also they get agitated. But I have to say that Gidi also has a way of taking it easy and cooling temperatures down. And after a while, where there was high voices, people start to calm down and ends up in laughter, and that is our joy. Then somebody asks about, do we have an extension? Normally, patanisho is a 30-minute affair. However, in some instances where the news are really like happening and we don't have time, we just tell the guys being reconciled to wait, and then after news immediately we finish it. We never have patanisho moving the second day. We don't extend it to the second day. It's normally fresh, it's there, it is solved. And our joy is also we have had a lot of feedback from patanisho people. You meet them in the street saying, "I Ghost, asanteni sana, unajua mlifanya tukarudiana na bibi yangu." Sometimes they write SMSs about how it happened, they were reconciled. Some maybe after that they've had a wedding and all that. So it's a lot of joy when you resolve conflicts through radio and it happens in real time and people come back together to reconcile. Otherwise, for this session, I want to thank everybody who has contributed, especially from the legal department. Fred Ogola, thank you so much. Joy also, and also Jemima, and also Adeline for being the host here. I mean, you've done a good job not forgetting Ann Karaoke. Thank you so much, and God bless you guys.
Oh, God bless you too. Makofi pia kwako. Thank you so much for that. As you guys have heard, yeah, young people, you can salvage those relationships. Yeah, I mean, it's open. So go to patanisho. Interesting, you know, there's no backlog of cases. It's a 1 hour affair. Should it be long? So you see, it is actually solving problems. So thank you so much. It has been an honor. I am your biggest fan. It's been a pleasure.
Thank you.
It's been a pleasure to host you. Thank you so much. I see that Ms. Jemima has not yet joined. Let me see. Okay, that's quite unfortunate, but maybe Mr. Gordon can say something as my fellow co-moderator, and then we can have Joe move a vote of thanks.
Just before Ghost leaves, I want to remind him of one incident in 2015 when him and Gidi were moderating a very interesting conflict. And at the end of it, Gidi started laughing and Ghost joined in the laughter. It was so infectious that the conflicting parties also started laughing. I also joined in the laughter. Unfortunately,
Yeah.
I was driving, heading towards a roundabout, and I forgot there was a roundabout, and I ran.
Oh,
That's how
sorry.
infectious it
Sorry
is.
for that, Gordon. We'll pay for the damages.
Asante. Otherwise, I'll be having one of our team members giving a vote of thanks. But on my side, I also want just to thank Joy, Jemima, Ghost, and Gidi for attending. At least at the end of the day, our viewers are very clear on what is the difference between mediation and AJS, what kind of justice are we accessing or dispensing through mediation or AJS, the need and the necessity to embrace this kind of multiple justice systems. One key thing that I've also come out with is the necessity to redefine what the question of repugnancy to morality is. Its morality is repugnant, or morality from what point of view, from which angle. And now that Article 159 recognizes these traditional methods, and you're still telling us that part of those traditional methods are repugnant to morality. I think time is ripe to be able to define and to redefine it. Otherwise, thank you very much, everybody. Back to my co-hosts.
Thank you so much, Gordon, for that. Thank you for helping me co-moderate. Miss Jemima, wherever you are, okay, in her absence, we want to thank you for being very insightful, for educating us, for taking your time and joining. But as of now, I want to invite Joe, who's the chairperson of the ADR club here at Kabarak, in charge of the students. He shall move his vote of thanks. Before he does that, I see that we continue having questions and comments. People are still inboxing me. If it is not so much, maybe we can have you engage with Joy, with Mr. Muley in their platforms. So we can find them in LinkedIn, Instagram, Twitter, and continue those conversations over there. I think that will be very productive, yeah? And yes, at this juncture, I want to introduce Joe. It has been an honor to moderate this session. Thank you.
Okay, thank you, Adeline. You can hear me? Okay. Okay, good afternoon to everyone. My name is Joseph Mungai, the chairperson to the ADR Club in Kabarak University. First, I would like to thank everyone for making this webinar success as we conclude this insightful topic, and which we seek to explore it further in the upcoming AJS conference. First, I would like to thank our esteemed panelists for their insights and expertise. They have granted us perspectives that we never had. And to Gidi and Ghost, we know this is a duo that all of us have grown up listening to, and we enjoy their authentic content. Also, Joy Gita, I would like to thank you for honoring our invite, and the same way to Jemima Aluda for also being part of this panel. Also to our moderators, Sir Gordon Ogola and Adeline Chalagat. Thank you for the seamless coordination and making this webinar engaging. And I cannot also forget to thank Kabarak University. I've seen our dean is attending. I want to thank for supporting us, because without them, this webinar would not have been a success. And to all the participants, the students, and all other policymakers and other stakeholders in the AJS practice, I would like to thank you for making parts and making this session an active one. And with that, I would also want to inform you of the AJS conference that is coming. The question you have probably they'll be addressed in the upcoming conference, and I hope to see you there. And maybe if to be live stream to be given to you. I also believe that this session, or rather the webinar, has acted as a feedback session, even to the policymakers on areas to improve, even to we as academicians or rather students. We have seen another field of law that has not yet been explored, and as well as we seek to mainstream the alternative justice systems. And as we go, maybe my take for the day, that is that we need to redefine justice and also decolonize the term justice. And as how Mr. Gordon has said it, that you also need to define what is repugnant. And with that, I want to thank you, and thank you all for joining us. Thank you.
Thank you so much, Joe. Thank you, our lovely audience, for being with us throughout the whole time. Now we are going to the last session. So to wrap up this conversation that we've had, I invite Dennis to pray for us, and then we can all leave at our convenience.
Thank you, Adeline. Let's believe and pray. Heavenly Father, we come before you with grateful hearts as we conclude these enlightening moments on the webinar of Alternative Justice System. We thank you for the wisdom and the knowledge shared today. Father Lord, even as we come to the end of this mediation and AJS talks, we remember our panelists, organizers, and every participant who has been present today. May you continue blessing them and give us the wisdom and the knowledge as we expand in the different fields. With that, I pray, trust, and believing. Amen.
Amen. Thank you so much, Dennis. Everyone, it has been such a pleasure to have you on board. Yes, Joy?
I just want to say thank you to Kabarak University and Patanisho. I just want to commend you for the amazing work you're doing. Let's keep advocating for this. Thank you.
Okay. Bye, everyone.
Goodbye.